Hi there. My name is Angus Wilson. I'm an associate at Samfir Tamarkin. I'm going to be here for the next half hour or so to answer any employment law questions you have. I will start with the caveat, the always here. This isn't legal advice. This is informational. And to get that legal advice, you can go to employmentlawyer.ca to book a consult. I'll do my best to provide any information I can with the limited time we have here. So Facebook, YouTube, Reddit, I think, anywhere you want to send me some messages, I'll have them show up here. And we'll see how many questions we can get through between now and 1:30. In the meantime, in the news, we've got a lot of layoffs starting. Federal workforce, on one hand, has announced that there's going to be over 15,000 federal jobs lost. Federal workers, if you're not unionized, there are some really specific protections that apply to your employment. Give us a call. We'll talk you through them. But just make sure, even if you work for the government, always talk with a lawyer before you sign anything. They may put some sort of an offer on the table. It may or may not be a good one, but you won't know until you check with us. So Citigroup is apparently slashing hundreds of jobs as well. Netflix is sweetening its deal to take over Warner Brothers, and we've got Amazon also slashing jobs. So if you've lost a job as a result of any of those or any of the other employers that seem to be downsizing, tech workers or otherwise, do reach out to us at employmentlawyer.ca, and we'll be able to have a longer conversation about it. Now, looks like there's quite a few questions rolling in here, so I'm going to switch over to that. Okay, so I've got a question on YouTube. Previous employer gave a negative job reference for an employee. It was based on an event that the employer didn't properly investigate. Is the employer protected by qualified privilege? So this is a really tricky question, and it gets into defamation law. This is ultimately something that kind of gets outside of the pure employment side of things. With defamation, there does need to be some sort of an untrue statement made. As far as qualified privilege, that I'm gonna have to take a pass on that question. Sorry about that. But the general side of things is that there are very few things that can happen as a result of an employer giving a bad job reference. If they're taking to the streets and saying so-and-so was a terrible employee, etc., it's a bit different, but ultimately that's something that gets outside of pure employment and more into defamation. I've got a question on Facebook from Ben. I was fired while on approved medical leave. Is that allowed? As always, the question is, or rather the answer is somewhat, it depends why you were terminated. They can terminate you during a medical leave, but it can't be because of the medical leave. So if you requested, say, a year off to recover from a surgery or something like that, they're not allowed to rely on that as a reason for terminating your employment. There's a few protections for that. Employment Standards Act has some protections. If it's relating to a disability, the Human Rights Code also has protections. The fundamental thing to notice is that you're entitled to notice a termination or pay in lieu of notice. So even if you've been terminated, even if you're on medical leave, get in contact with us at employmentlawyer.ca. We'll be able to have a longer conversation, look at what reasons there might be for the termination. And if you're terminated because of that, there's a lot of different places we can seek a remedy from your employer on. So Ben, I hope you contact us at the link below, and we'll be able to have a longer discussion about that. Okay, I've got a question from Bass Poet. Maybe it's Bass Poet. I'm not sure if you're a DJ or a fisherman, but either are super cool. So we've got can Manulife, my long-term disability adjudicator, cut off my long-term disability benefits before I return to work? Mr. Poet, that is unfortunately a little bit out of the scope of what I'm able to provide answers on today. We do have Martin Willems, who will be hosting a long-term disability specific stream at some point soon. Looks like we're looking at February 10th at 10 a.m. Western. So tune back in then, and he'll be able to provide clearer information on that. The intersection of LTD and employment is a really complicated one, and certainly we'll be able to have a longer discussion about that if you book a consultation. But Martin is going to be able to provide some more information on February 10th. Okay, I've got a question on YouTube from Omar. I was fired for poor performance, but never received any warnings or review. Omar, I've got a few follow-up questions. Whether they terminated you for just cause, claiming that poor performance was a reason, or whether they simply said, here's, you're being terminated, here's your notice, and by the way, it's because of job performance. That gets into two separate things. So typically, an employer needs to provide you notice of termination unless they have just cause to do so. They have to prove just cause, and ultimately, that poor performance is not going to be something that they're going to be able to terminate you for just cause unless they've warned you, unless they've given you adequate time to improve, tools, training, the whole host of things. So if you've never had a warning and your employer's terminated you for just cause and paid you no severance, definitely get in contact with us. That's something that we do and deal with all the time. So contact us at employmentlawyer.ca, and we'll be able to discuss a little bit more in detail what we'll be able to do for you. Bill Petroza on Facebook. If you apply for a new internal position and your employer gives you a new employment agreement and you sign it with a provision that if you're terminated, your common law, okay, I'm getting a little lost in the sauce here. Let's just say a few months after being in your new role, your common law entitlements under the ESA applying, but your severance is cut down to 8 weeks. Okay, I see what's going on here. Bill, this touches on a lot of issues. I'll try to be as comprehensive and quick as I can in the time that we have. One of the issues is going to be, is there a binding employment agreement? So you typically need something called consideration to make a binding employment agreement. And that means you're given something of value. So if you're given a promotion, if you're given a raise, typically that is going to be something that is factored in. Where it gets a little bit into the gray is if they gave you the raise and the promotion just so that they could get you onto a contract that gave up your common law entitlements, and then they terminated you because of that. That's essentially bad faith dealing at that point, and a court may find that they're not able to rely on that. So this is a really complex argument we're talking about here with limited time to do so. So what I'll just say is contact us at the link down below, employmentlawyer.ca, and we'll be able to really dive into the weeds of this situation. There very well might be something that we can do here. It's an exciting, from a legal point of view, it's an exciting argument to run. And I think that there's probably some great work we'll be able to do for you. I've got a question on Reddit from Sophia. My employer changed my commission structure right before a big sale closed. Is that legal? Sophia, commission payments are super complicated. They are almost always changed for the employer's sole benefit. because they've decided that they don't like paying their people as much as they agreed to. So the actual way that they brought this change into effect, when it came into effect, how much of the work was performed beforehand? Are we talking a day? Are we talking a month? Are we talking longer than that? All of these are going to be relevant factors in terms of whether you're entitled to more commission. So what I certainly just flagged for you right now, a lot of wage complaints can be dealt with through the Employment Standards Branch. If you think that you're entitled to more compensation as a result of this change to your commission structure, that is a free service that you can go to enforce that. Now, on the other hand, if we're talking about major changes, if we're talking about this is perhaps the first time your commission structure has ever changed, generally speaking, employers can't just make unilateral changes to your employment. And in certain circumstances, that can amount to something that we call a constructive dismissal. So rather than simply being a change that you kind of gotta love it or leave it, and ultimately decide whether to accept it or quit, well, that in itself could be evidence that this is something that could be a constructive dismissal, which allows you to treat your employment as having been terminated and pursue severance against them. I will just note, commission structure changes, often they've happened before. Often it's not enough to trigger constructive dismissal, but I aim to cover everything. So that's something that we'll be able to discuss in greater detail if you contact us at employmentlawyer.ca. Very suspect from just an initial little blurb that I've got on the side of my screen. Get in touch with us and ultimately perhaps pursue that employment standards remedy. Drew, okay. This is a great question and I get it a lot. My employer is offering severance but wants me to sign a release right away. Should I be worried? It's a bit of a red flag. If they want you to sign right away, if they say you can't leave here until you sign this, don't listen to them. By terminating your employment, they've brought that relationship to an end. So figure out what you're entitled to first and foremost. Talk to a lawyer. You can get in touch with us if you like at employmentlawyer.ca, but importantly, talk to a lawyer about this. Their pressure probably means that they're trying to get you to accept something that is less than your entitlement. Could be a lot less, could be a little less, but generally speaking, when we see this kind of pressure and they say, you got to sign it, if they refuse to give you extensions, it's one of those situations where if I owe you $100 and I say, okay, if you sign this that prohibits you from suing me, I'll give you $30 right now. Well, you'd be crazy to jump on that and say, okay, I'll take the $30 in exchange for a release. So talk to a lawyer because there may be a lot more than they're offering to provide. On the other hand, if they're providing only the employment standards minimums, that's not going to fly. Get in touch with us at employmentlawyer.ca below, and we'll be able to discuss that. Okay, from YouTube, I've got Afia PL. I'm back. All right. Thanks, Afia. My sister-in-law just found out that she's not being brought back to her position after mat leave. The replacement is keeping her job and they want her to take a lower position at less pay. Does she have to do that? No, she does not. If she refuses the position, is that like quitting? No, it's not. What does she do? Contact us. This is something I've dealt with a lot and quite frankly, more and more often lately. I'm not sure what it is, but employers are getting really, really cocky with this kind of thing in terms of often they know what they're supposed to do and they'll just decide, well, it's working okay with the new person. So definitely get in contact with us. What we're talking about is something that deals with human rights because she can't be discriminated upon based on family status or gender. The other side, Employment Standards Act. That is a job protected leave, and the Employment Standards Act means that they need to offer her the same position or a comparable position when she returns. If it's lower paying, that's not that. And there's also the possibility of pursuing claims in court. So ultimately, yeah, it's a mess. And I see that you said new owners, it's all a mess. Yeah, change of management, it's something that she definitely benefit from a consultation. I will be able to hop on a phone with her as soon as next week if you like. My information for this, I believe we'll be able to put that up right there. Send her that QR code, take a screenshot, do what you need to do. I've dealt with this a lot, and very, very recently as well. So we'll be able to get in touch and talk strategy. All right, Anya Seats from YouTube. I've been dealing with harassment at work. It's a very male-dominated industry, and when I bring it up, I'm often labeled as delicate. What do I do? How do I make this stop or change? This is one of the toughest things to deal with in employment, is how, when you're still employed and you're still looking to keep up with that relationship, how do you make it work for you as an employee? Ultimately, and I will just say I'm familiar with the expression that HR is not your friend. Well, it's kind of true, but at the same time, what HR does is HR is there to limit liability for the employer. So where there's harassment, where there's something that ultimately they're not living up to their end of the bargain to keep you safe at work, HR is where you go. And when HR fails, you go to WorkSafe BC. WorkSafe BC regulates workplace health and safety. That includes bullying and harassment. And ultimately, WorkSafe BC can order that they do a new investigation, can order that it's perhaps an external investigation. The quick notes of this is that you are entitled to a fair, impartial investigation of your complaint. You might not ever know about what the specific steps the employer has taken, because that deals with employee confidentiality on the part of the harasser, ironically. But you should have confirmation that an investigation happened. You should have some confirmation that it is being addressed, and whether it's substantiated or not. If you don't like the answer, or if they don't take that step, immediately report it to WorkSafe BC, and they'll put them on the right track. Once you've reported it to your employer, ultimately they also have a duty to investigate. And if they just say you're being too delicate, etc., and there is some clear harassment going on, that can also be a constructive dismissal of employment, which is something we discussed earlier on in the call, because they have a duty to keep you safe in the workplace, uphold health and safety, and ultimately, if they're failing to do that, whether it's physical safety or emotional safety, that can be the basis for you to get out of that situation. So ultimately, contact us down below. We'll be able to discuss whether there's anything to do beyond escalating to HR, WorkSafe BC, etc. But ultimately, those are the steps that you need to take before anything is going to change. And if they just disregard you, certainly get in touch with us, but certainly keep escalating it, and that involves bringing it to the regulator. Question from Evan. I complained to HR about harassment and was terminated a month later. Could this be retaliation? It could be. Without more information, it's tough to say. How long were you employed before? Was it substantiated or unsubstantiated? How did you feel the investigation went? If you got the sense that they were covering things up, or you went after a powerful person that ended up signing your termination letter, it looks a little suspect. Ultimately, dealing with issues of harassment at work, it can be a really black and white thing. Most often it's in the gray, and it can be a challenging claim to bring. Have a discussion with one of our lawyers at employmentlawyer.ca here. we'll be able to discuss what possible remedies there are, and also take it from there. What I will note on harassment, there are certain things that fall within essentially management that sometimes, and I'm not saying this is relating to either of these situations, but sometimes what seems like harassment is chalked up to management. If there are legitimate performance concerns, having coaching conversations on that isn't necessarily harassment, but you'll know when it crosses the line. And when it does cross that line, certainly get in touch with a lawyer to discuss what steps can be taken. I've got a YouTube question from Zoe. I work remotely and got written up for quote unquote not typing enough. They monitor our keystrokes and mouse movement. Is that considered invasive? It depends. Are they talking about just simple keystrokes? Are they talking about pulling actual content of it? And thirdly, are we dealing with your computer or the work computer? When we're dealing with an employer-provided computer, they do have fairly wide powers to put software on there to ensure that they can manage the employment relationship. When it works best, for remote work, people manage themselves quite well, generally speaking. Your employer seems to have a bit more of a focus on tracking what happens, which it's unfortunate. Anyways, can they do that often? Yes, but it depends on what they're collecting. Have they gotten your prior informed consent? Do you have an idea of what this is being used for? And those are things that even within the employment relationship, which under the Privacy Act has a fairly broad exception to dealing with managing the employment relationship, you do still need to be informed about what they're doing and why. Surreptitious recording, that's going to be a really, really severe thing. I mean, if you're in your home and the webcam turns on, that's a bit of a different thing than simply logging how many times a mouse is clicked or keystrokes are made. So yeah, it is a little bit invasive. It more likely than not is something that is indicative of not a lot of trust, but it may be okay, depending on what I've discussed there. All right, Jonald, I've got a question from YouTube. If you work in the trades and are let go permanently, when you might normally have a seasonal break, are you owed severance? Employer says no, we don't get severance in construction. So, Jonald, I used to work for the Employment Standards Branch. I've got a really good grasp on what that legislation says. Under the Employment Standards Act, there is an exception for construction workers to getting any notice. Now, the determination of are you construction comes down to whether your employer is a construction employer. So is it a construction company? Do they do framing, cement work, that kind of thing? And do you work on construction sites? So if you're working back in the shop and you're doing prefab homes, that's probably not going to be construction under the Act. You're probably entitled to it. But if you're working on job sites, if you're reporting every day to a construction site and every few weeks it's a different one, or every few months it's a different one, you may be covered under that exemption for just the ESA. Here's where it switches, is that Employment Standards Act exemption doesn't necessarily apply to your common law entitlements. I have and will continue to negotiate severance packages for construction workers. So if you've worked there for a long time and you've been brought back year after year, if we're talking maybe about a short, like two-week break, 4-week break, that's ultimately going to be a situation where you may still be entitled to compensation based on the fact that you've been going back to work year after year, and suddenly they say, this is the end of the road, you don't get anything. I don't like the sound of that. So get in touch with us at employmentlawyer.ca. Link will pop up at the bottom here, and we'll be able to have a discussion about your specific situation and whether there's anything to be done about this. I think there probably is, but we'll cover off all of our bases and see what we can do. All right, we're at 1:28, so we've got a couple more minutes here. If there's one more question that comes in, I'll be able to address it. Otherwise, I'll talk a little bit more. Hey, there we go. Sandra on Reddit. My employer says my termination pay is limited to the ESA minimums. Do I have any entitlement beyond that? Sandra, thanks for giving me a quick and easy one here. Depends on what your employment contract says. If you don't have an employment agreement in writing, then you're entitled to common law notice. If you've got an employment agreement in writing, they still might have messed up on how it's drafted. And I make a living by picking these things apart, and employers will mess this up so often, how they draft a clause. So absolutely get in touch with us. We've got a link down below for employmentlawyer.ca. You probably do. I can't tell you without reviewing documents and things like that, but certainly don't take your employer's word for it. You're going to be looking at potentially a lot more compensation. Jonald, I've got face red, droopy eyes showing up. The actual emojis themselves didn't. Hopefully I answered your question, and thank everyone for coming out today. We will have another live stream coming up, typically once a week. So we've got Chris Justice, based out of our Ontario office, 1:30 p.m. on February 2nd. So you don't have to wait long. After that, we've got a fairly regular cast of people a couple of times a week to talk about Ontario, Alberta, and BC employment law, long-term disability questions as well. We've got a great group of people that will sign on and take your questions there. So thank you all for coming out, and have a great rest of your day.